We are back on MorningLine, News Channel 5, legal analyst Nick Leonardo with us this morning talking about some high-profile cases. Just with regard to the wooded rapist, I wanted to touch on that. We know that Alex Friedmann we were talking about. Wooded rapist, were you even born when this case happened? No.
I didn't have nearly the gray hair that I have now.
Jeez.
We covered it gavel to gavel.
Yes, we did, and that's right. But I'm just saying, you're a young man, and this goes back to, I think it was 2008 to 2010 when those trials went on. The wooded rapist represented by, among other people, I guess it was one of the first trials Mary Elena did. Fletcher Long, Kerry Gassaway represented him. Very disturbing case. This individual accused of, in the dark of night, going into homes and raping women, and he got away with it for a while.
And they got him because somebody had the wherewithal to, when he was in a restaurant, to get a utensil. It was a fork or spoon that a police officer got and did a DNA match.
And the way they got them, what did they match it up with? One of the victims took a bite of his hand while she was being raped and had a piece of flesh in her mouth they kept. And then there was another time where he was spotted in the area, but they didn't have enough to get him on anything, but he became a suspect, and they said, we need to match his DNA with this flesh. And they got it, and they got their man.
Well, because, you can charge DNA to total statute of limitations. So clearly, I believe, if I'm right, his DNA sequence was already charged with a crime. They just didn't know the identity right until then.
Exactly. It's a fascinating case, horrible case, disturbing case. To this day, I'm still the only reporter that ever did a live face-to-face interview with him. Scary guy, because when you sit with him, kind of a handsome fella, soft-spoken. Every word out of his mouth to me was a lie. Okay, but I interviewed him, tried to press him on it. This was 2 days before his trial, his first one, and he ultimately was convicted in a series of 2 or 3 trials. Now, here's the interesting thing. Last year, at some point, it finally came up, his request. He was appealing on grounds that maybe the evidence wasn't enough to convict him, blah, blah. That was denied. No new trial. Now, if you would, explain to people what post-conviction relief is.
Okay, post-conviction relief is part of the 3-tier appellate process we have in the state of Tennessee. So if you're convicted of a crime by a jury, you can appeal that to the Court of Criminal Appeals, which is a 3-judge panel, higher court, and then from there you can go to the Supreme Court if they'll accept it. Okay, that's one tier. The other tier is habeas corpus, which is available all the time, every day, at multiple times, and there's 2 grounds to be successful, and that is the court was without jurisdiction to sentence you, or your sentence has expired, which are really heavy burdens and are rarely granted. Then the third one is post-conviction relief, and that is where the defendant has exhausted all the other appeals I've talked about, and within a year's time from that, they would have to go into court and argue that they did not receive the effective assistance of counsel, and they have to show by, it's a high burden, but they have to show by clear and convincing evidence that their counsel's performance A was deficient, that's easy to show, okay? And no one's perfect. But the harder part is the second prong of that, and that's that they were prejudiced by that deficiency, or the outcome at trial would have been different. And then post-conviction, everyone does that, and they should do that. That's a right. But we also see a lot of DNA, and these post-convictions being the procedural vehicle to retest DNA, or potentially there's new evidence that's come out, and they're keeping all that evidence forever. But clearly, like you said, that some woman had put that into her mouth, while she was being raped, and as technology gets better, maybe it would come back that it wasn't his DNA, or maybe maybe there's something there that could be argued because it's been, what, 12 years now, or 11 years? So clearly science has gotten better, and he's serving an exceptionally long sentence, so he has nothing else to do, quite frankly, than pursue as many appeals and appellate avenues as he can come up with.
So this is pretty standard stuff. Now, my understanding is most defendants do this, but his family, his mother, this is a privately retained attorney that they are paying for, and a lot of inmates don't. They just file their own, or they get the pro bono work. But it's a private attorney hired by them to file this motion, I guess, arguing this. So what will they do then? You imagine?
The only remedy if you're successful in a post-conviction petition, then your case would be overturned, and then you'd be facing that pending charge again. So in his case, there were several counts, okay? I don't know if he's challenging all those counts or maybe he's just challenging one count. But clearly, a win in a post-conviction proceeding is to have your conviction overturned, okay? So then you could go back to a new trial or plead guilty. And a lot of times, people end up getting a pretty good deal in sentencing, or they get a plea offer, that's better than what they would have got if they were convicted. And so, I always tell people, be careful what you wish for, because, you may have a basis to overturn your conviction, but you may get greater punishment if you have to go forward again.
Yeah, but he's locked up pretty much for life. And so, by and large, this is standard stuff. I mean, would you, based on what you and I both know about this case, he's not going to win, and even if he were unlikely to win in this one case, I mean, he's never getting out, is he?
Well, no, I mean, these counts are consecutive, I believe, right? I mean, and so they're stacked one on top of the other. So if one or two of them were overturned, then he's still got other, counts that are holding him in sentences that he's actually serving. Unless this is going to the heart of all of them, which is a DNA case. Remember, it was a DNA case. Remember we sat here for a long time and thought, how do you beat the DNA, right? I mean, how are they going to get past that? And they didn't. The jury didn't find it.
You just can't. How do you beat DNA, Nick?
Well, I mean, obviously, what's the likelihood, because it comes back.
Some samples are better and more effective than others.
Right. And was it contaminated? Okay, was it put in a brown
chain of custody,
all those kind of things. I mean, DNA is sort of hard to beat, and so you do all you can as a defense attorney to maybe poke holes in that. But again, if it comes back that it's 98% likelihood it's you, And
as we think back to the trial, what we can remember of it, did you get a sense, and we always talk about it, you'll be watching when we do gavel trials and go, Nick, that's something that might come up on appeal, or that might come up, and I can't believe the judge allowed that, or this or that. I came out of that, especially the first trial is the one I remember most, thinking that the defense did the best job they could. I mean, do you think there were glaring examples of poor legal counsel?
I think Fletcher Long, Kerry, when they were lawyers, they were good lawyers. Nothing stands out. It's been a long time. We've covered a lot of trials since then, but nothing really stands out to me as error. I believe it was wasn't it Judge Norman that did that trial?
I think so.
I believe
remember in one of the trials, the jury actually on one of the charges came back with one lesser charge. I forget what it was. Right. It was one lesser, but I mean, still very significant, and he still eventually was locked up on all of them. But if you are looking for small victories for him or the defense, that was it. I mean, the fact that they got back with one of the charges, a lesser charge, that I just thought, I don't see where there's just blatant examples of, poor legal representation.
No, I didn't. I mean, I didn't see that. I mean, the best I could recall, everybody did a really good job. And I mean, it's, again, it was the DNA, and of course I remember the victims coming in testifying and how horrific those experiences were.
That's the one thing before we go to this break on this, when these things come up, I think there's a hearing scheduled, status first, and then there may be a hearing actually to discuss the issues brought up. The victims, they have to go through all this again. Would there be any, obviously they may be aware of it, and if they choose to, they could show up, but there's no reason any victim, unless there's a new trial ordered, which I don't think will happen, would have to be part of this, right, at this stage? No,
not unless there's a new trial. I mean, obviously, I can't imagine that anything in a post-conviction would have to do with a victim's, somehow we've shown that they lied or something. I just haven't seen that, and I don't think that would come up. The problem, though, is that we're talking about it, other news agencies are talking about it, and those poor victims, if they're flipping through the TV, they, trying to move on with their lives.
But they probably want to know if it's up, too, though. I think it's certainly worth reporting. It was such a big story. I'm sure they'd want to know that he's up for this. It's just, they probably want to, but they hate that it happens.
Well, sure, and of course, it's a tough burden for him to overturn his conviction. Again, it's clear and convincing evidence, which is the highest burden of proof we have in America. It's more than beyond a reasonable doubt, okay? Clear and convincing would be, first and goal with inches, right? That's how far you got to take that ball.
Take a break. When we come back, I want your thoughts on one of the high-profile cases that captivated the country for a period of time. Some people are really glad it's over. Other people missed watching it, and I'm talking about Amber Heard and Johnny Depp. Just an interesting development with regard to the jury and her request for a mistrial, which was denied, but where she goes from here, that case isn't closed. We'll be back, get his thoughts on this in our final segment right after this.